problem of national security, which is intimately connected to a more absolutist or thick version of sovereignty, and its relationship to law is not unproblematic. And in the context of nuclear weapons, historically, that is a more accentuated concern. It was in the late 1940s, I think, or 1950, when Dulles, who was Eisenhower's Secretary of State, addressed the American Bar Association, and the central point that he made was that since the nuclear age, the UN Charter was now obsolete. In effect, what he was saying was that international law is obsolete, irrelevant to the conduct of the high issues of state and so on. As a matter of professional understanding, Kennan and Morgenthau, two rather prominent Americans in the 1950s, both took the position that bringing law to these weighty questions of national security was a hopeless illustration of useless utopianism, and in fact it was dangerous. So that's sort of the background, and for a long time there was the feeling that law couldn't really contribute to this. Law itself is not a static discipline, and one of our well-known fellows in the academy took the issue up, wrote some important pieces on the question of the lawfulness of the testing of nuclear weapons in the South Pacific. And in this course, he generated some more modernized and novel versions of what law is all about. And in particular, he had to confront, on the one hand, the constituency of hard realists who just don't think law's got anything to do with it. And those hard realists come with a sense of cynicism, which may still pervade this discourse at that policy level. So, in some ways, for law to be meaningful, it had to account for the realism of the context and find a principled and rational way to bring that context to bear on the problem you sought to resolve. And then secondly, the context implicates basic value, and law unguided by basic values doesn't have any authority component, has no believability, has no currency, certainly not in the world of articulate public opinion. So it was important that these two issues of realism and values be connected in a meaningful way, and in a very old tradition of law, essentially established by the great Dutch jurist Hugo de Groot, who in the early 1600s wrote a famous book called De Jure Vera Practis, One Piece, in which he brought the idea of reason and reasoned elaboration to international law and to the way in which sovereigns ought to behave. So he reinvented that tradition, so to speak, in the 1950s. And I should say that one of the judges in the 1996 opinion, Judge Wiramantri, was also followed in that very same tradition, and many scholars have regarded Wiramantri's dissent, which is an over 200-page dissent, as one of the most eloquent expressions of the Croatian tradition in international. Why it would be important for the court to revisit its 1996 judgment. He's gone through most of the changes that have taken place over the last 15 years. In short, whatever it did in 1996 didn't have the constraining effect on how we control, how we regulate, how we move purposefully in the direction of getting rid of the stuff. So that was really what we were trying to get at, and he has already explained that. What I then tried to do is to make sure that we understood the problem of, really what I was attacking was the problem of thick sovereignty. And thick sovereignty is essentially national security, and thick sovereignty, national security, and nuclear weapons basically carry the imprimatur of no accountability. So you have to bridge that gap theoretically to get at the problem. Alan did make the point that one of the most important cases in the 20th century was the Lotus case, the one to which you referred, in which basically the court endorsed the notion of a thick sovereignty, an unaccountable sovereignty. If you can't point to a particular rule that constrains France, you can't hold France responsible for the events that took place on the high sea. And what that means essentially is that you're allocating literally an unfettered competence to the state, generally, not just, and of course your mind has to go back to precisely the unfettered sovereignty that got the world stumbling into the First World War. You know, everyone was going in and no one really knew why. And once they were in, they didn't know how to get out of it. And so the question is still remain, well, how much of the thick doctrine of lotus continues to haunt our modern concerns and so on. And people like me feel lotus is a very dangerous precedent and ought to be confined to its historical circumstances. In any event, that got us into thinking about the developments in the aftermath of the great tragedy of the Second World War, and what emerged from that was a very explicit effort to confront the problem of unlimited sovereignty. And that membership in the UN is conditioned on your willingness to accept certain international obligations. The foundation of the system is based on the principle, as I said earlier, of we the people, and in effect, sovereignty is subordinated to the major purposes that make the system what it is, and the legal values behind the system that sustain that system in the common. And so additional indicators, of course, are the emergence of such notions as obligations erga omnes that are universally binding on states, and the principle primarily out of human rights law of jus cogens, peremptory principles of international law that clearly trump the sovereignty principle. If we want realism, we have to understand the problem, and you can only understand the problem if you understand the context, and the context is absolutely critical for any rational legal reappraisal of the legal status of nuclear weapons. The specific contextual background of nuclear weapons, starting out with the unique nature of its, the amount of energy displaced in the detonation of a nuclear weapon, the idea that a 1 megaton bomb has the destructive capacity of some 70 Hiroshima bombs. In fact, if I'm correct, scientists can bear me out, but most of the predictions in the testing of nuclear weapons usually underestimated the amount of energy that was actually displaced. So, with those startling indicators of the unique nature of the bomb, which is an important element of context, I then looked at the question of the nuclear threat to a viable ecosystem, including the issues of nuclear winter. And in this regard, I looked at the question of when you have the detonation of nuclear weapons, what about the lives of the radioactive nuclides and the extent to which, as in the case of a nuclear explosion with a byproduct of plutonium-239, it will apparently last for 20,000 years, retaining its lethality for human beings and other forms of life. And so, moving that into the context of the broader ecological consequence, the idea of a predictable nuclear winter, if sufficient bombs are exchanged, is a real thing. And even though there may be particularized participants, the effects of nuclear winter will be global. And that would affect the food chain. It may lead to mass starvation of millions and millions of human beings. Then I went from there to from the environmental context to the medical appraisal context. If I'm correct, I believe that it wasn't the lawyers that were the moving force of this, it was the medical, and that was because they had come to the conclusion in their own studies that if there were exchanges of nuclear weapons, there basically is no medical response. We just don't have the burn facilities, we don't have any way to realize. The lucky ones are the ones who are dead, but the survivors will suffer with no medical. That led them to the idea that the only real medical option here is to do whatever we can to prevent nuclear weapons from getting. And that was one of the movements that went through WHO, and eventually that movement led to the development of this opinion. It wasn't the lawyers' view, mainly it was the medical profession. So I looked at the medical evidence and developed by a number of experts and expert groups. And of course, the medical evidence is quite stunning. We've seen some of it over here, its impact on human reproduction and so on. And it's almost unanswerable if you look at what the medical effects will be of the exchange of nuclear weapons. And as a consequence, if you wanted realism, this is realism with a vengeance. I then moved from an assessment of the medical consequences as a background context of the issue to the next component of legality, problem, context, realism. That's what we look at on one hand. And then the question is, and what exactly are the values that are at stake? But given some guidance in this, in the dissenting opinion of Judge Weramantry, in which he distilled 6 keynote values that permeate the UN Charter, which is essentially our global constitution, and it is, for however we may regard it as a weak constitution, it is the codification of the most durable values that make social coexistence and some social progress possible. And so we have the principle of humanity, the idea of the rights of future generations, the dignity and worth of the individual human being, protection of human aggregates, large and small, the importance of law and other sources of law, and the promotion of social progress. Almost all of these values are compromised by the threat or use of nuclear weapons. And from that, and with the clarification of the values and the context, I then went into the more specific questions of what are the precise rules at stake here. And there is the law, or the jus in bello, the law that happens in time of war. I looked at this fairly carefully to see what the traditions predated this, and some of the religious traditions, particularly the Hindu tradition, in both the Ramayana and Mahabharata, there's a clear reference to the accessible in the war, to hyper-destructive weapons of this. And in each of these instances, the oppositive players reject such weapons as completely antithetical to any sense of morality, even in time of war. And so, from the Martin's Clause, which then covers, we don't have an explicit reference to nuclear weapons in these systems, but we do have the Martin's Clause, which by interpretation can be used to cover that, you see, rationally. We find huge dimensions of land and populations that are covered by nuclear-free zones. That is, again, it may not stand as universal law, but it stands as a powerful indicator of expectations of what is lawful that people have now. Specific rules of humanitarian law, the prohibition of unnecessary suffering, the proportionality, the discrimination between combatants and non-combatants, prohibition of genocide, and environmental law and human rights law. Fundamentally, any appraisal of the context and consequences of a nuclear exchange makes the entire corpus, every single one of these rules, irrelevant. It destroys them all. So I must jump forward. I then did examine the question of self-defense, which is what the court had indicated could be an exception. But even the law of self-defense is subject to the law of war. That is to say, it has to be necessary, it has to be proportionate, and it has to respect the principle of humanitarianism. And quite clearly, even in self-defense, a nuclear weapon would not simply respect these principles. So that whether this should be read as some vastly unintended exception to the law of war is. Finally, in my discussions with Gary, we did raise the question of the possession itself, whether should you really have a right to possess the weapons at all. And we can't find a case rationally that relates to law that says, yeah, you can. The nature of the thing does constitute a threat. It can be stolen. It can be appropriated by terrorist agencies. It creates a certain mantle of insecurity in people. It really has psychological effects on vast aggregates of people. And as a consequence, we don't think, at least I don't think, that you could really make that case. That doesn't mean that because you may not have a right to possession, that international law insists that you automatically give everything up. Law requires some reasonableness in the way it's implemented. So that means that there's an important directive on states to move in the direction of what the NPT says to get rid of the stuff as soon as possible. Thank you.